Welcome, everybody. My name is Camden Hutchison. I am the director of the Center for Business Law here at UBC, and it is my pleasure to introduce Professor Brian Fry. Professor Fry is a professor at the University of Kentucky College of Law. He teaches and researches in the areas of intellectual property, copyright, trademark, nonprofit organizations, art law, civil procedure, professional responsibility, contracts, property, constitutional law, and media law, as well as intellectual property theory and popular culture more broadly. So a very, very broad research and teaching program. He's been a visiting professor at a number of schools, including the Maurice A. Dean School of Law at Hofstra University, Tulane University School of Law, Southern University Law Center, and Jilin University Law School. He has published more than 100 academic articles on a wide range of subjects, and he is best known for his work on plagiarism, blockchain, and legal history, as well as his practice of creating conceptual art in the medium of legal scholarship. Today, Brian will be discussing his very interesting project, The Economics of Authenticity, Securities Regulation, and the Art Market. And I will go ahead and let him begin his presentation. Thank you, Professor Fry.
Thank you, Camden, for that very generous introduction. I'm delighted to be here in beautiful Vancouver. I always enjoy visiting Canada. We had a lovely drive up to Lillooet over the weekend and got to take advantage of the Fraser Valley and all the beautiful scenery up there. So I'm really delighted to be here. So as Camden mentioned, today I'm going to be asking and hopefully answering the question or the statement, why art is not a security. And you might be wondering why we would ask this question or why we would consider this question in the first place, right? After all, how could art be a security? Well, I hope I can get you to see why that might be a question worth asking and why the answer to that question might be interesting, but it might be a bit of a circuitous path. So I'd like to start by asking the question, what is a security in the first place? Now, of course, this is a question defined by national law, and different countries have different answers to the question. For the sake of convenience, I'll sort of rely heavily on United States law because it's the law with which I'm most familiar. And I think a lot of other countries kind of borrow from United States security law and securities law concepts in many respects, for better or for worse. So United States securities law essentially didn't meaningfully exist until the early 20th century as states started adopting blue sky laws. But the real kind of core to United States securities law was created in 1933 with the Securities Act of 1933, which provides us with a statutory definition of a security, which has persisted pretty much unchanged since that time. And it's very broad, right? It defines a security in relation to a number of different concepts or ways in which people go about selling and making investments with a catch-all category of investment contract, right? So investment contract was included in the definition of securities to make the definition as broad as possible, as a kind of extra category we can put in any transaction or any investment that may be characterized in a way that isn't necessarily captured by the language of the definition, but that nonetheless we think the government and specifically the Securities and Exchange Commission ought to be able to regulate. The question then became, how do we know whether or not a particular investment is or is not an investment contract for the purpose of the Securities Act, and therefore something that falls within the purview of the SEC to regulate? In other words, is the SEC statutorily authorized to regulate this particular kind of investment? Well, the Supreme Court answered that question to some degree, or at least provided its initial answer to that question about a decade after the securities laws were enacted in the well-known case SEC v. Howey. And just a little bit of background, because I think it's actually helpful in kind of understanding the context and might help illuminate some of what I'm saying later in the talk today. The Howey case actually involved an investment in orange orchards. Right, so there was the owner of a very large orange plantation in Florida. They wanted to attract investment capital to to their orange orchards or to their orange operation, but they didn't want to go through the traditional procedures of registering with the Securities and Exchange Commission because it's burdensome and expensive, and perhaps they also concerned that the SEC might not sign off on the particular investment opportunity that they were planning to offer to the public, in part because orange orchards were seen, I think quite rightly, as a kind of a scam of the early 20th century. So what they did instead was propose to sell slices of the orange orchard to investors with the promise that they would, the company that owned the orange operation would perform all of the cultivation and picking and selling of the oranges in question, and the owner of the slice of the orange orchard would be entitled to a percentage of the profits generated by the particular slice of the orange orchard that they owned, which they had no obligation or need to ever visit themselves. In other words, the ownership of the piece of the orange orchard was effectively a fiction created in order to enable the orange orchard to sell off fractional interests in their business operation while characterizing what they were doing as the sale of land rather than a share in their business operation. And the SEC brought an action against them, arguing that they had failed to follow procedures in registering the offering with the SEC, and that therefore they were in violation of the securities laws. And the question became, right, or the question before the court was, is the investment being offered by the Howey company a security or not? Or rather, is it an investment contract under the 1933 Act? And the answer provided by the Supreme Court was unsurprisingly yes. What was interesting was not what the answer was, but how the court reached the answer in question. And what the court did was promulgate what has become known as the Howey test for whether or not a particular investment opportunity is or is not an investment contract and therefore a security. And what the Supreme Court said was that what you look to is 4 different factors, right? We ask whether the investment in question is an investment of money in a common enterprise with the expectation of profits from the efforts of others. And that test has remained more or less consistent over time. The only real difference, or the only really major development since the Howey case was decided was that the Supreme Court initially used some language to the effect that the efforts had to be only from the efforts of others. And the Supreme Court later said, no. When we say only, we don't mean that, if you do anything yourself, it's not a security. So long as there's some expectation of profits from the efforts of some other people, it can still be an investment contract and therefore security. Even a little bit more broadening, but more or less effectively the same standard since 1946. And this has become relevant recently, or it's always been relevant, but it's become relevant in a new way recently as the SEC has been thinking about crypto markets and different kinds of crypto assets, and whether or not the SEC is authorized by the securities laws to regulate them. And we'll return to that in a moment, right? But before we get there, I want to take a little excursus. Right. So I should say that there's kind of a sense among securities lawyers that the Howey test is kind of incomplete. So my friend Ben Edwards at the University of Nevada, Las Vegas Law School, who teaches securities law, among other things, has kind of characterized this as the 5th shadow factor of the Howey test, right? Does the investment in question look like a security, right? And that, kind of a very Potter Stewart-esque, and I know it when I see it sort of feel, to the 5th factor. But in a lot of ways, this 5th shadow factor is really the most important one, right? Because the way the SEC regulates, unlike many other agencies, is through enforcement, right? We say regulation by enforcement, which means that the SEC tells the kind of investment community what does and doesn't qualify as a security, among all the other questions that the SEC answers, by bringing enforcement actions against people who do things that it believes they're not entitled to do or that are prohibited by the securities law. So rather than kind of promulgating regulations through a traditional traditional notice and comment process. The SEC instead primarily makes regulatory action through enforcement actions, but does have a process known as a no action letter. Right, which will, again, we'll return to no action letters later for reasons that you might find interesting and amusing. But in effect, a no action letter is a way for a participant in the securities market to ask the SEC whether or not they're allowed to do something. Right, so what you do in a no action letter is you send a request, you request a no action letter from the SEC by telling the SEC what you want to do. Right, you describe in great detail the investment opportunity you propose to offer to investors, and you say to the SEC, if we do this thing exactly as described, will you bring an enforcement action against us? And the SEC, in its discretion, will review your proposal. And if it thinks it merits a response, it will tell you yes or no as to whether or not, if you do exactly what you've described, they believe that they will bring an enforcement action against you. Now, they're not binding, right? The SEC could change its mind. Right? If it decides, wait a minute, we thought that was not that this was permitted, but it turns out we actually don't think it's permitted on the back end. But typically, once the SEC has issued a no action letter saying that if you do this thing, we will not proceed against you, it abides by the no action letters that it issues. And what's more, other participants also rely on those no action letters. So they're not literally binding on others, but they're sort of an indication, or they're taken as a statement by the SEC to the broader community as to what it does or does not consider to be the subject of an enforcement action. And so the discretion of the SEC is very important, right? The SEC has no obligation to bring an enforcement action. It brings enforcement actions when it believes it is entitled to and should do so under its mandate as an agency under the securities laws. So this fifth shadow factor, right? Does it look like a security? Sounds a little bit unhelpful, but it's actually really important. Right? Because the SEC ultimately makes the decision about how it's going to categorize different kinds of investment opportunities, what it's going to regulate, and what it's not going to regulate. Okay, so let's take a big step over to the side then and think about the art market. What is the art market? I'm going to define it very narrowly. Right? So this is something I've found to be quite important. Right? When I talk about the art market, I'm not talking about people buying art because they like it. And I'm not talking about people buying art for decoration. Right? When I talk about the art market, I'm talking only about the market for art as an investment. Right? So the art market is the market for the kind of art that would be sold at, say, for example, an auction house like Sotheby's or Christie's, the kind of artwork for which there is a secondary market. Right? So the way I like to illustrate this is that for the overwhelming majority of art, 99.99% of what we would describe as art, there is no secondary market. Right? You walk into an art gallery, you go to an art fair, you buy an artwork. The minute you buy that object and from the person who is selling it to you, its value is effectively zero. Right? You may be able to sell it to someone else as a consumption good or as decoration, but there is no secondary art market value for what you have purchased. Right? It is purely a consumption good. It's something you either like or you don't like. It's not an investment good. It conceivably could become one, right, in a very small number of circumstances, right? If the artist who created it becomes famous or important, right, there could be a kind of a subsequent unexpected creation of a secondary art market for the object in question. But the overwhelming majority of objects are purely consumption goods, and the art market, defined as most broadly, is primarily a market for consumption goods, with the exception of this very specific, very rarefied market for art as an investment good. And the illustration would kind of be like, look, nobody's paying $10 million for a painting just because they want to hang it on the wall. Right? They're paying $10 million for a painting because they think that there's a reasonable likelihood that they will be able to resell that painting in the future for more than $10 million and make a profit on it. That's what makes it an investment market rather than a market for consumption goods. And that's the only market I'm talking about in this talk. I'm not talking about the market for art as a consumption good. And so the assumption that art collectors make when they purchase artworks in the art market, right, or the belief that they have when they purchase artworks in the art market, is that there is at least a possibility that the art will increase in value in the art market over time, and therefore they will be able to increase the value of their investment if they hold on to the artwork in question. And when does that happen, or what affects the value of the artwork in the art market? Well, the in effect, the popularity of the artist who created the work. Right? If the artist becomes more popular over time, then typically the value of their artworks will increase over time and the investment will appreciate. If the artist becomes less popular or becomes ignored over time, then the value of the artwork in the art market will decline and in fact may decline all the way to zero. Right? So the value of artwork depends entirely, value of artwork in the art market depends entirely on the popularity, or to put it in kind of law terms, the commercial goodwill associated with the artist in question. Okay, so how about that, right? All we have to do is squint a tiny bit and we can see how the art market satisfies the Howey test for a securities market, or rather we can see how the sale of art in the art market as an investment easily satisfies all four prongs of the Howey test. After all, art collectors are investing money in artworks in the art market, right? They're spending money. They're giving money to a gallerist, or they're giving money to an auction house in order to purchase the artwork in question. They're investing in what amounts to a collective enterprise managed by the artist, right? Artists sell lots of different artworks to lots of different collectors, typically, but the artist is ultimately in charge of what they're creating and what they're selling. And what's more, the artist is in charge of managing their own career. Right? The artist, in some sense, or at least attempts to have control over their future popularity. And the increase or decrease in the popularity of the artist is managed, if anyone, only by the artist in question. Right? They own their commercial goodwill, and they are in the business of managing and growing and harboring and protecting the commercial goodwill associated with their brand. Art collectors hope to profit from the purchase of the artworks in question. In other words, they're buying the artwork in the art market because they think it's going to get more valuable and that they will generate a profit as it gets more valuable because the artist has invested in the development of their career, and they expect others than themselves to be increasing the value of the artwork in question. Specifically, they hope that the artist and the artist proxies will be investing time and energy in developing the brand of the artist and thereby increasing the value of their investment. So, all four factors of the Howey test very clearly satisfied. And looking at specific examples of artwork, of historical artworks, I think we can actually illustrate that observation even more clearly. I think it applies very broadly, right? But as I'll explain later in the talk, I think it can be hard for us to see when it comes to kind of more conventional artworks, because we've come to understand them as objects, and we've come to understand the art market as a market for objects. I think that's entirely wrong, okay? I'll explain to you later why I think that's wrong, but I think some of these particular artworks might help you start to see why I think that's wrong. So you may be familiar with the Dadaist, surrealist conceptual artist Marcel Duchamp. In 1924, Marcel Duchamp created a really, to my mind, very interesting artwork titled the Monte Carlo bonds. And they were styled as a bond investment in a secret investing strategy for playing roulette in Monte Carlo. Right, so Marcel Duchamp sold these bonds to prospective investors, art collectors, right, on the theory that the bond represented a investment in Marcel Duchamp's future winnings at the roulette table in Monte Carlo, and he sold quite a few of them. Right? Now, the reality, of course, like so much of Marcel Duchamp's work, was that the value of the artwork, right, the value of the bond certificate that he sold to the investors was much higher than the promised winnings, which in fact never materialized. It turns out that Marcel Duchamp was a much better artist than he was gambler. I believe he lost all of the money invested in this particular project. But the investors, the art collectors, did quite well, right? Because the Monte Carlo bonds are now worth quite a pretty penny, despite the fact that the promised return on investment never never materialized. I submit that what Marcel Duchamp was selling was effectively, he styled it as a security, but what he was really selling was an investment in himself or an investment in his own career. And I think we can see that the kind of the dematerialization of the art object in the works of more recent artists, like, for example, Sol LeWitt, right? Conceptual artist, actually arguably coined the term conceptual art, or at least offered the kind of earliest popular definition of conceptual art. Sol LeWitt is well known, among other things, for his wall drawings, which consist of instructions for creating an artwork drawn in various ways on the wall of really wherever the owner of the artwork wants to put it. And in Marcel, or rather in Sol LeWitt's understanding, or in his description or characterization of the artwork that he's selling, it's not the wall drawing itself that constitutes the artwork, right? It's the concept of the wall drawing. And so what he sells to collectors is not the drawing itself, but rather a certificate that recognizes their ownership of the wall drawing artwork in question. So here you see one such certificate that describes what the wall drawing in question would conceptually look like, and a certificate stating that the person who purchased the certificate in question is the owner of that artwork, and they are the owner of that artwork whether or not the artwork in question is ever materialized. And according to Sol LeWitt, the wall drawing is authentic if and only if it is realized by the owner of the certificate, who has purchased ownership of the wall drawing in question, and who can then alienate the certificate to someone else and make them the new owner of the wall drawing in question. And we can see it in the work more recently of the Italian artist Maurizio Cattelan, created and showed in 2019 at Art Basel, a conceptual artwork titled Comedian, which consists of a banana duct tape to the wall. And of course, the specific banana and specific piece of duct tape taped to a particular wall does not constitute the artwork, right? The artwork in question is the idea of duct taping a banana to a wall. And Maurizio Cattelan created an edition of 3 of that conceptual artwork, which he sold to 3 different collectors for, I think it was roughly $250,000 per edition. So it's a very lucrative concept in question. Well, why does that matter, right? Let me take a step back, right? This project started for me quite some time ago, right? So before I went to law school, I went to art school and did a Master of Fine Arts at the San Francisco Art Institute. After law school, like many artists do, I went to work at Sullivan and Cromwell, a white shoe securities law firm in New York City. And while I was working at Sullivan and Cromwell in their securities litigation group, I was tasked, among other things, with kind of figuring out whether particular investment opportunities were or were not securities that would be regulated by the SEC. And it struck me in the course of doing that work that the SEC's description or definition of a security as mediated through the Supreme Court sounded an awful lot like conceptual art. I mean, after all, when you buy a Sol LeWitt wall drawing, how is that different? Or when you buy a Marcel Duchamp Monte Carlo bond, or an edition of Maurizio Cattelan's Comedian, how is that any different from buying a bond certificate, right? Or buying a stock certificate, owning a investment in the artist in question? And I started kind of puzzling over this idea, asking myself, like, how I could explain this, or explain this observation to people. And I found it quite difficult, right? Because when I talked to other securities, or when I talked to artists, they didn't know what I was talking about. They were like, securities law, what do you mean? We're artists, we make art. This has nothing to do with securities law. This is just lawyer brain talking, Brian, move on and don't bother with this. When I talked to securities lawyers, they were equally puzzled. They would look at me and say, why would anybody buy something like that, right? That doesn't make any sense. What are you talking about, right? So I realized I needed to do something different to help people understand the point I was making. And I think actually a nice illustration of that is that, unbeknownst to me, about 30 about 30 years before this kind of occurred to me, a law student at Fordham Law School, Maureen Holm, published a student note titled "The Art Investment Contract and Application of Securities Law to Art Purchases," in which she made a very similar observation to the one that I was making, although she did draw very different conclusions from it. She observed that the art market looked a lot like a securities market and called for the SEC to institute regulation of the art market as a consequence. She said, well, if the art market looks like a securities market and art purchases look like securities contracts, then or investment contracts, then the SEC ought to regulate the art market. For better or for worse, her article was almost entirely ignored. No one really talked about it. And the SEC actually did issue a response to a request for comment, stating, or rather, it was effectively a no action letter from someone asking whether or not they should be concerned about selling artwork in the art market on the grounds of securities laws. And the SEC said, no, we have no intention of regulating the art market. So I kind of closed the matter for the time being. I realized that this problem or this question needed to be approached in a different way, and so I wrote several different papers. The first of which was titled "SEC No Action Letter Request," and my kind of idea with this paper was that the conventional way of explaining ideas via legal scholarship is to write a paper, right, very forthrightly explaining to people the observation that you've made, why the observation is important, and how you think the problem in question ought to be solved. I realized that just wasn't going to work. I needed to activate the observation. So what I did instead was I wrote a paper titled "The SEC No Action Letter Request," which was styled as the prospective for the sale of an investment contract taking the form of a work of conceptual art. Right? So the work of conceptual art was titled "SEC No Action Letter Request." It consisted of a SEC no action letter request, or sending a no action letter request to the SEC, proposing to sell a work of conceptual art by that very name in an edition of 100 for $10,000 per edition. I wrote the paper at the end of 2019, and just before the new year, sent a no action letter request to the SEC, making precisely this proposal, attaching my article as a prospectus for the proposed offering, explaining to the SEC why what I was proposing to do very clearly and explicitly satisfied every single factor of the Howey test and all the kind of accompanying factors that the SEC considered in asking whether or not an investment opportunity was or was not a security, among other things. I proposed to recruit law professors to market the work of conceptual art on my behalf, and I proposed to invest proceeds from the sale of editions of the work of conceptual art into the promotion and sale of future editions. And so as a consequence, I explained to the SEC in the no action letter that I sent to them that what I was proposing to do was in fact the sale of an unregistered security, and therefore they should deny my no action letter request. So a friend of mine described it as the first ever SEC action letter request. For better or for worse, the SEC declined to respond to my no action letter request, as is its wont. I was a little disappointed, but it was not a big shock to me. I did hear from people I knew who I had either worked at or had worked at the SEC that there was considerable internal discussion about this particular request, positive, negative. I'm not quite sure. In any case, I filed a Freedom of Information Act request with the SEC, asking them to produce any documents pertaining to the no action letter request that I filed. They declined to respond, citing administrative privilege. So they just said, no, we're not going to respond to this FOIA request at all. But lucky for me, a law student friend of mine at Cardozo also sent a FOIA request to the SEC, requesting any documents associated with my no action letter request. And somebody at the SEC screwed up and failed to respond to my friend's no action letter request in time, precluding them from asserting the administrative privilege. And therefore, they were obligated to respond to his FOIA request substantively, which they did by producing everything that I had sent to them, along with 15 or 20 pages of fully redacted documents internal to the SEC, including the only information, substantive information that he received from the SEC was part of a single email from an unidentified staffer at the SEC, which among other things described my theories as fanciful, which I found quite delightful. So that was kind of the initial saga of my SEC no action letter request project. I kind of let it lay fallow for a little while until the NFT market blew up. Because the response that many people had made, so among other things, this initial project was circulated pretty widely on Twitter, and among other things, it caught the attention of financial journalist Matt Levine, who publishes a newsletter every day, pretty much every day, titled Money Stuff, very popular Bloomberg newsletter. He commented on my project in part because he was well known for saying everything's a security if you want it to be, right? He said, well, maybe not this. And the kind of typical response that people made was, well, yes, this is very funny and clever, but no one would actually buy this, and you weren't really actually selling it, and you didn't actually make an offering, and yes, there's certificates out there, but you gave them away for free rather than actually selling them, et cetera. And you will notice that I promised to sell it in addition to, or I proposed to sell it in an edition of 50, but in order to kind of make the project more interesting, I diluted my own offering by providing 200 certificates of ownership to people. I wanted to kind of make it even more securities fraud than it initially was. So the response from a lot of people, both in the securities world and the art world, was, well, this isn't really a securities law violation because you weren't serious, right? You didn't really mean it, and no one was actually going to buy it. The NFT market came along, and I realized, wow, there's this beautiful market in nothing that's perfect for my art project. So I immediately reissued my SEC no action letter request conceptual art project as a set of securitized NFTs, which you can see here. I put them up for sale in September 2021. The entire edition sold out in 20 minutes, and I made about $40,000 in ETH. At the time, I think it might be worth more now as ETH has gone up. I converted it to dollars, or rather, I converted it into a Mustang GT 5.0 for my wife. It's the car that NFTs bought. Anyway, so it did sell out immediately, which I felt really put the lie to a lot of the criticism, or the skepticism that the project received, right? You said that this wasn't really a securities offering because no one will buy it. Well, look, I just sold $40,000 worth of this conceptual artwork. How about them apples? Right? In any case, I did a number of other NFT projects, but this is the relevant one for this particular project. And so what this really illustrates to me is the economic reality of the art market. We talked about that earlier, right? But, as Walter Benjamin observed, 150 or about 100 years ago now, the art market is a market for authentic artworks. What does that mean? What is the concept of authenticity? We have a kind of lay understanding, or kind of initial understanding of what authenticity means. An artwork is authentic if the work was actually created by the artist to whom it's attributed. But that concept of authenticity pretty quickly breaks down, especially in relation to conceptual art, right? What makes a Solowit wall drawing authentic, right? If you execute the drawing exactly as described by Solowit, Solowit will say, well, it's not authentic unless I say it. Well, he would have said that. He's dead now. But yeah, he would have said, right, it's not and the art market still does say, the wall drawing in question is not authentic unless it's authenticated by Solowit or his representatives. And the same would be true of Maurizio Catalan, right? Anyone can duct tape a banana to a wall, but it's not an authentic edition of Maurizio Catalan's Comedian unless it's been endorsed by Maurizio Catalan himself. And it turns out that that's true of all artwork, right? We think that's what's valuable is the art object, but that's wrong, right? And I can illustrate it very simply, right? You might buy a painting in the art market believing that said painting is authentic and very valuable, right? But if it turns out that that painting is not included in the relevant artist's catalog raisonné, in other words, if it's not recognized by the artist or the artist's estate or the artist representatives, the value of that artwork on the art market is zero, right? Even if it turns out that as a matter of fact, the attributed artist did in fact create the artwork in question. And in fact, the film director Orson Welles in his documentary F is for Fake, which is about the art market, illustrated this problem or this conundrum really nicely in an anecdote that he told about Picasso, right, in which Picasso created a drawing on a napkin for someone who gave it to him. And then the person said, well, thank you for this authentic Picasso. And Picasso says, no, that one's a fake. And the recipient said, no, Picasso, I just saw you draw that drawing in front of me. And Picasso said, well, I can create a fake Picasso just as well as anyone, right? So what makes an artwork valuable isn't the provenance of the object or the fact of the matter as to whether or not the object was or was not actually created by the artist in question or is identical to what the artist created. The authenticity is determined by the artist's catalog raisonné, whether that exists as a document or exists merely conceptually, right? The authenticity of an art object is determined by whether or not the art market is willing to attribute a particular object to the artist or not. In other words, the art market is effectively a market in catalog raisonné entries, or we might say the art market is a market in ledger entries. And those ledger entries are represented by physical tokens we refer to as paintings or sculptures or drawings or whatever, but those physical tokens are only representations of ownership of the ledger entry. They aren't ownership of the ledger entry itself. And what matters is ultimately only the ledger entry. In other words, there's really no difference between an art object and a bond certificate. And Marcel Duchamp figured that out over 100 years ago, right? So I think that even more effectively illustrates my observation that at least on some level, when we think about the economic reality of the art market, what we're thinking about is a securities market, right? Well, what then is the NFT market, right? An NFT is a cryptographic token that represents ownership of something, right? Typically ownership of an artwork. And you might like the artwork associated with the NFT, you might not, but that's irrelevant for the purpose of the market. After all, it doesn't matter whether you like the artwork in the conventional art market or not either, right? The question is merely whether or not the art market as a whole values the artwork in question. And when you buy an NFT, what you're doing is buying a ledger entry that represents ownership of the artwork in question. In other words, the NFT market and the art market, the conventional art market, are literally identical to each other in almost every respect. The only difference between the two is that the conventional art market still relies or leans very heavily on physical tokens as a way of representing ownership of the valuable ledger entries, whereas the NFT market does away with the physical tokens entirely and allows the market to proceed purely on the basis of ownership of the ledger entries with no need for the ownership of any physical token whatsoever, right? So in other words, the art market has always been a securities market of a sort, and the NFT is a securities market of exactly the same sort. It just uses cryptographic tokens rather than physical tokens. And here I show you a photograph of the thinker Sigmund Freud. All right, I want to invoke one of Freud's many provocative theories. Freud described the uncanny as that which makes the familiar unfamiliar, right? Or rather, Freud described, what he meant by that, right, was that the uncanny helps us see, right, that something that once seemed familiar is no longer familiar, or as I think is actually even perhaps better put, right, the uncanny or an uncanny object helps us realize that what we thought was familiar actually had never been familiar to us. In other words, what we thought we were seeing was never what we were actually looking at, right? And so I like to refer to NFTs as uncanny tokens, right? We thought we understood the art market as a market for physical objects, for authentic physical objects. What the NFT market shows us is that what we thought was familiar about the art market was never actually familiar, that the art market had always been a market in ledger entries and had never been a market in physical objects. And the NFT market shows us that by stripping away the physical tokens and showing us the face, the kind of the true nature of the market in question. And much as the uncanny, or as in Freud's kind of characterization, the uncanny makes people uncomfortable, I think the NFT market made people uncomfortable in the same way, right? People hated it because it forced them to come to grips with a reality that they found very uncomfortable, right? People don't like thinking about the art market in this kind of cynical, finance-oriented way. We have very kind of romantic ideas about the nature of art and the market for art, and we want it to be a market about true authenticity and art making, whereas in fact it's just a financialized market like any other financialized market. And as a digression, I actually think that's really good for the concept of art because it enables us to kind of to distance the aesthetic appreciation, the meaning or the kind of aesthetic value or social value of artwork from its financial value in, I think, socially useful and productive ways. But that's for another day, right? Okay, well, what happened, right, was the SEC on some level caught on, although I think not very effectively, right? When the NFT market started, right, there was a percolating or a great concern among participants in the NFT market, right? They realized that what they were doing looked an awful lot like a securities market, in part because many of them were participants in the financial industry or the securities industry and knew what a security looked like and realized that what they were buying and selling sure looked awful lot like what they were doing in their day jobs, and in fact often became their day jobs, at least until the market cratered for the time being. And so they were very concerned about how to prevent or how to avoid SEC enforcement actions. And the question going around among, and I observed this as a kind of dilettante participant in the NFT market, the question going around was, well, how do we describe the project that we've created and are selling in order to avoid SEC enforcement actions? And that made me, it was kind of so charming that they would think about it in that way, because of course, it doesn't matter how you describe it, right? The SEC looks to the economic reality of the transaction you're proposing, not how you characterize that economic transaction. And in fact, the Howey case we talked about at the beginning of this lecture, right, is a perfect illustration of that, right? The whole thing that the Howey company was trying to do was characterize the investment that it was offering in such a way as to make it not a security. And the SEC and the Supreme Court said, that's not how it works. Right? That's not how it works. We don't care how you talk about it. We care about what you're actually doing. We care about what you're actually selling. We care about the economic reality of the transaction you're proposing, not how you describe it to people. Right? So they, I try to tell people this, right? It doesn't matter how you describe it. What matters is how the SEC sees it. And Gary Gensler, then chairman of the SEC, famous crypto skeptic, he saw it as a security and decided that he was going, in fact, to bring enforcement actions against these kinds of products. Now, NFTs and the NFT market were relatively low on his list of priorities. He initially proceeded against larger and to him, I think, more concerning areas in the cryptocurrency market. But the SEC did eventually get around to bringing enforcement actions against NFT projects, among other things. It brought an enforcement action against Impact Theory, which was sold a collection of NFTs it referred to as founders' keys, which would kind of give people a unspecified ownership of the sort of notion of their business. It was very unclear as to exactly what you got when you got a founder's key. I think the answer is you got nothing other than an NFT and bragging rights to say that you were an investor in Impact Theory. Even more to my point, right? They brought an enforcement action against a NFT project called Stoner Cats. When you bought a Stoner Cats NFT, what you got was the NFT associated with a picture of a cat with the promise that someday they were going to turn this into an animated cartoon, which I believe they ultimately did, although it didn't end up being very successful. In any case, what was interesting about both of these actions was that the defendants settled And the SEC knew they would settle, right? Because the SEC brought enforcement actions against projects that had already sold out, were no longer valuable, and where the creators of the projects, who were the defendants in the actions, had literally no incentive to defend themselves against an SEC action, right? All the money was gone. They had no prospect of making more money. It would have been throwing good money after bad to hire a lawyer in the first place, or really to hire a litigator. What they needed was someone who could bargain with the SEC, so they'd have to cough up as little money in fines as possible. So the SEC got settlement agreements from both of these defendants. Those settlement agreements came along with very heated dissents from a minority of SEC commissioners who objected to the SEC bringing these actions in the first place in ways that I think are interesting but not really fully realized or articulated. Effectively, they said, what are we doing here? This doesn't make any sense, right? How are we characterizing these as securities? What's our theory here? And what was interesting to me as a artist, as a law professor, as someone thinking about securities laws and the nature of securities, was that the SEC didn't seem to have a theory of what it was doing, and was in effect trying to sort of create facts on the ground and say to people, hey, we don't want you doing this kind of thing, whatever this kind of thing is. But what I realized was that, this made no sense, right? However, it was a perfect illustration of what I've been saying all along, right? I filed those no action letter requests in the past, and in fact, I filed a second one when I did the NFT project, right? I'd filed the first no action letter in end of 2019. When I created the NFT project in 2021, or rather, no, this was 2021, not 2019. In any case, when I created the NFT project in 2021, I sent a second no action letter request to the SEC saying, in effect, I still think that what I'm doing is selling unregistered securities, but I'm going to take your refusal to respond to my last no action letter as your tacit admission that you don't think it's the sale of unregistered securities, and so I'm just going to do it anyway. Nota bene, does not work that way, right? The SEC has no obligation to respond to your no action letter, and if they do not respond, you cannot take that as acquiescence, right? So do as I say, not as I do, right? I don't want any of you to be liable for securities fraud. In any case, and then most interestingly, the SEC also instituted an enforcement action against OpenSea. This was the real shot across the bow, right? Because unlike impact theory and stoner cats, OpenSea was still a going business concern. They had plenty of money in the bank and plenty of incentive to defend themselves against an enforcement action, because after all, the SEC's implicit theory would have meant, in effect, a death knell for their entire business model. Right? I mean, if the SEC could proceed against any NFT project on the ground that selling an NFT was per se the sale of an unregistered security, then OpenSea is out of business, right? They can't operate anymore. So the CEO of OpenSea, Devin Finzer, said very openly, we're going to fight this tooth and nail. We're not going to give in like other projects have done, and we're going to kind of put the SEC's feet to the fire and make them defend themselves. But I was there first. So in 2024, late summer of 2024, I and another artist filed a declaratory judgment action. We sued the SEC essentially in the Eastern District of Louisiana, asking for a declaratory judgment that selling artwork as an NFT was not per se a violation of the securities laws. That litigation is still ongoing, but in effect, what happened was, I forgot to put it in there. Well, in any case, the other artist, Jonathan Mann, is best known as Song a Day Man. Every day for the last 10 years, he has written, recorded, and released a new song. And for quite some time now, since the NFT market first took off, he's been selling each one of those songs, auctioning them off as an NFT. So selling NFTs is in fact his livelihood, right? And he proposed in this litigation to sell a particular song in a collection of 10,000 plus editions that people could mix and match as however they wanted to. And his statement was that he was concerned about the sale of this NFT collection in question, based on the SEC's enforcement actions against Stoner Cats and impact theory, as well as its initiation of an enforcement action against OpenSea. I proposed a project titled Cryptographic Tokens of Material Financial Benefit, which consisted of a issuance of 10,320 NFTs, each of which conveyed the feeling of being a winner, and nothing more, and proposed to sell those for 0.1 ETH each, noting in my proposal that my project was exactly the same, like literally exactly the same as the Stoner Cats project. And I know this because I very intentionally plagiarized the Stoner Cats project, only I made mine worse, right? Because you didn't get any artwork associated with your NFT. All the NFTs are associated with the exact same image, which is basically just the title of the NFT project in question. All you get is nothing, literally nothing. You get nothing but an investment in Brian L. Fry being a conceptual artist. So we filed this action. The SEC did file a motion to dismiss, which was supposed to be have an oral argument a few weeks ago. However, in the interim, we had a change of administration in the United States. The new commissioner, or the new chairman of the SEC, seems disinclined to pursue actions against NFTs or like any crypto assets, let alone NFTs. And in fact, the SEC has dropped all of its pending enforcement actions against various NFT projects and companies, including its enforcement action against OpenSea. As far as I know, the only live litigation is our lawsuit in the Eastern District of Louisiana, and the SEC asked for a 60-day extension on the oral argument, which I sadly suspect will never happen at this point. I think it's pretty unlikely the SEC is going to continue to fight this particular battle given the change in administration. But the conceptual point, I think, still remains, right? What's the problem here, right? I mean, all of these projects, the entire NFT market, held the art market, right? As we've seen, all satisfy the 4 Howey test factors for being a security. Why shouldn't the SEC be bringing enforcement actions? Why shouldn't the SEC be regulating the NFT market? Why shouldn't the SEC be regulating the art market? Well, I want to go back to Howey, right? And suggest that the reliance on the Howey test, or rather the prioritization of the Howey test as the message provided by the Howey case, is actually misplaced, right? And I think what the Supreme Court was actually saying in Howey is better characterized as an exhortation on the SEC and on the lower courts to ask the question of economic reality, right? What's the actual nature of the transaction in question? And I think what we've been characterizing as the Howey test is just the Supreme Court giving an example, right? Saying, this is one way you might go about doing the analysis of whether or not a particular investment that somebody's offering is or is not a securities offering, but it's not the only way. And merely satisfying these 4 criteria doesn't determine whether or not a particular investment opportunity is or is not the kind of thing we think of as a security. We have to think always about the economic reality of the transaction in question. And that, I think, is where the SEC's case, not only against the NFT market, but against the broader art market, collapses, right? Because what is the economic reality of the art market? What is the economic reality of the NFT market? Well, you're selling effectively an unsecured interest in your future commercial goodwill, right? Unlike a traditional securities market, where what you're selling is an unsecured interest in future profits, right? So I think the big difference, right, the thing that makes ultimately the art market and the NFT market, broadly speaking, not securities markets, in other words, not per se the issuance of securities, is that when you buy a work of art, the artist doesn't have an ongoing obligation to give you anything, right? And they don't have an obligation to do anything. You might want them to, right? When people buy artwork, they want the artist to continue promoting their art. They want the artist to continue promoting their career. They want the artwork to be more valuable in the future. But if the artist doesn't follow through, or the artist fails, right, or it turns out that the artist has no interest in pursuing a further artistic career, the collector has no recourse against the artist, right? All they own, in a kind of technical sense or in a practical sense, is an interest in the commercial goodwill associated with the artist, whether that's an artist in the conventional art market or an artist in the NFT market. They own that interest in the commercial goodwill, and that's it. They don't own a share or interest in any kind of tangible future revenue stream, right? Now, does this mean that artwork, that NFTs can never be securities? Absolutely not. Right? Again, it depends on the economic reality of the transaction, right? So way back when, in the 80s or 90s, David Bowie proposed to sell what were referred to as Bowie bonds, right? Or interests in the future revenue streams from the royalties associated with his songs. And those were bundled, and there was a prospectus filed with the SEC that signed off on the sale of Bowie bonds as securities. And I think that's right. Because in that circumstance, what the investors were buying was not merely an unsecured investment in the commercial goodwill associated with David Bowie, although I imagine that really helped with their willingness to purchase the particular investment. What they were buying was a share of the future revenue stream. And that kind of investment opportunity has been packaged and sold subsequently in relation to many different musical artists, as well as celebrities and especially sports stars, right? They've been able to securitize their future revenue streams in that way. I think that is properly characterized as a security because it's an interest in a future revenue stream. Right? Likewise, there are art investment companies that sell an interest in an art portfolio, right? Shares in an art portfolio. I think that's also properly characterized as a security because it's an interest in the revenue stream generated by returns on the investments of a business. My only point is it isn't necessarily a security, even though the market in question has features of a securities market, specifically the ability to securitize commercial goodwill. And I think that itself is actually really important. And I believe that it almost certainly will be the future of the market in investment and innovation and in creation, right? As the value of, as a kind of traditional methods of distributing works of authorship become less and less sensible, right? As the transactions costs on the creation, reproduction, and distribution of works of authorship gradually approach zero, right? I think that the market for creative works is going to move into more of a trademark style, more of a market based on commercial goodwill associated with the brands of an artist or creator. And that the NFT market offers us a vision of what such a market might look like, right? People investing in the commercial goodwill associated with artists rather than buying copies of their artwork. And in the long run, I actually think that will be very good for artists. So there you have it.
Well, thank you very much, Brian. We have plenty of time for questions. I guess I might ask the first question, although I'm not sure if it's fully formed within my mind. So one thing I struggled with a little bit in your analysis of the art market and your comparison of the art market and the NFT market. So you described the art market as, sort of people investing in the future commercial goodwill of artists, which is dependent on the artist's future efforts. Mm-hmm. And I'm not an expert on the art market, but aren't art investors sometimes investing not in the future efforts of the artist, but they're sort of speculating on the changing or improved reputation of the artist, which might be dependent on art critics or other, mediators of aesthetic value. And those changes might, I'm thinking of somebody like Van Gogh, who is underappreciated during his lifetime, but of course his works of art are very valuable today. Mm-hmm. I guess So two questions. One is is that am I just wrong about that? Or do art investors actually speculate on, just speculating speculating on the future value of an artist brand independent of that artist's efforts, right? More dependent on changing taste, I suppose. And then if I'm not wrong, then like how does that fit into your theory of what is or is not a security?
Yeah, I mean, I think what you have to do is conceptualize an artist as kind of an inchoate business, right? So they may not be kind of incorporated the way we would do formally with a business offering shares normally. You might think of it as more like an unincorporated association or a partnership of kinds, right? So it's a business in the sense that somebody or some group of people are controlling what counts as representative of an interest in that artist's career and what doesn't, right? So there are people out there who implicitly or explicitly authenticate, is this a real Van Gogh or is it not a real Van Gogh, right? Who decide what counts as an investment in the social capital associated with that particular artist. And we see that with all different kinds of celebrities, right? I mean, after all, Elvis has been dead for a long time, but Elvis the brand is still very valuable, right? And the same is true of many other celebrities, right? We don't conceptualize them as a business operation, but as a fact of the matter, they are a business operation. And we ask questions about who does and can own a share. And then when it comes to artists, you can own a share in that business operation by owning an authentic artwork associated with the artist. When it comes to other celebrities, you have to own them in different ways, whether through the right of publicity, whether through trademark law, or even just through sort of social convention or custom, right? Like what's recognized as counting as an authentic articulation of that celebrity's endorsement, right? Something associated with the celebrity in question, right? Who's in a position to monetize that celebrity's brand? So, I mean, you're right that it's not kind of formalized in the same way that we would think of in a traditional securities market. But again, right, as the Supreme Court has instructed us, I think we should be looking to the economic realities of what's happening rather than the kind of formal ways that we describe it. And the practical reality of the economic reality of how the art market works is that when you transact in artworks, what you are effectively transacting in is a fractional interest in the social capital associated with the artist in question, even if it's hard for us to kind of put that on a one-to-one basis with a kind of traditional securities market, right? So it's more about kind of saying, let's think about how the market actually works, even though it seems like a peculiar way of it getting there.
That makes sense. Thanks.
Sure.
You can just be here.
Sure. Yeah.
Thank you, Brian, for your entertaining and informative talk. I have a couple of questions which unfortunately are not entertaining at all. So I'm sort of counting on your providing the entertainment factor here. So first, I mean, thinking of Walter Benjamin that you mentioned, I was wondering, wouldn't you say that the art market has simply changed since Benjamin's time, so that nowadays, at least part of the art market is no longer a market for authentic artworks? That's one question. And the next one is, I was simply wondering, I mean, do all artists in existence designate some of their works as recognized and others as unrecognized? Right? That was unfamiliar to me. And then I was wondering, I mean, you said that an investment isn't a security, in your view, unless investors reasonably expect a future revenue stream based on their investment. So if I'm not wrong, many people buy equity, hoping to resell, essentially, and not counting on dividends being declared. So how does that square with your definition? Yeah. And finally, I was wondering whether subjecting artwork to SEC regulation might have some value in view of the use of the art market for money laundering by criminals.
Yeah. So these are all great questions, and I'm glad you brought them up because they're things that I intend to work in one way or other to the paper I'm kind of proposing here or subsequent papers as well. When it comes to Benjamin, I think what he was doing was making an interesting and important observation that helped people understand the art market at the time better than they had previously, even though he was wrong. Okay, so I think that the art market as an investment market emerged before Walter Benjamin wrote his famous essay, Art in the Age of Mechanical Reproduction. I think that as a kind of quirky quasi-Marxist theorist, he was doing his best to offer a kind of Marxist account of the art market that salvaged some version of the aesthetic appreciation that he cared so much about and that the other members of the Frankfurt School really didn't, at least not in the way that he did. And as a consequence, he was sort of trying to rehabilitate, I think, in some way, the art market that he saw already existing as a market in authenticity, which we might take to be good on some level, as opposed to a purely financialized market. And so, Benjamin envisioned a world in which the decline of capitalism would lead to the freeing of artwork from the kind of strictures of authenticity. I think in Benjamin's worldview, authenticity was kind of a stand-in for capitalism, right? And that we could transcend capitalism in the art market by transcending authenticity. For better, for worse, Benjamin's prediction didn't bear out because I think that capitalism is just too seductive. So, oh well, sorry, Walter, we didn't quite get there. Your second question was about
whether all artists designate some of the work.
Right. Yes. Yeah. So, Amy Adler at NYU actually has a recent paper where she kind of digs really deep into precisely that question, kind of thinking about the history of authenticity, specifically in the modern era in relation to conceptual art. Conceptual artists have done all kinds of weird things when it comes to authenticity. For example, some conceptual artists or some kind of minimalist artists will declare particular art objects to no longer be authentic because they've been altered or damaged or changed in some way. They'll say like, that's no longer my artwork because it got damaged, or you let it deteriorate and then fixed it without my permission. Or like, that's no longer my artwork just because I don't own it anymore, right? I reject that work or body of works from my oeuvre. There's an interesting question, can they do that? I don't know, right? I mean, I like to answer these questions in a practical way and say they can do it to the extent that the art market recognizes it, right? So if an artist says, that's no longer my work, I no longer recognize it as authentic, the art market as a whole wants there to be some arbiter of authenticity and inauthenticity. And I think it's willing to accept a certain degree of arbitrariness on the part of artists and artists' estates simply because they need a decider. And the value of having a decider is worth a certain degree of arbitrariness. I also think that if the artists or the artist estate take it too far, then the art market is probably going to start ignoring them or taking them less seriously, right? So I suspect that there's a tipping point, right, at which the value of certainty will be outweighed by the cost of uncertainty. But I don't know, right? And it's actually, I think, a really interesting practical question.
So here's another, if I may follow up briefly,
Yeah.
here's another practical question. Let's say that you're the artist, as you are, and I've purchased one of your works based on the strength of your express or implied position that is an authentic work of art. And next month you have a change of heart and you declare this work that I purchased as inauthentic. Do I have a cause of action against you?
This is also a really interesting question, which has actually been litigated kind of in certain circumstances. There have been a number of collectors who brought actions against artists or artists' estate on the ground that the artist has disavowed or has denied the authenticity of particular artworks. Most of those have been unsuccessful, but the facts haven't been quite as clear-cut as what you described. There's also been, I think, a very interesting action where a collector brought an action, I believe it was against the Eggleston estate on the ground that they had purchased a vintage Eggleston print in the understanding that that edition would remain fixed and that no additional prints would be made. And then the Eggleston estate released a new edition. And the question was, well, is that in effect diluting the value of the purchase that they made? The court said no, but essentially because there was no explicit promise that they wouldn't release a second edition and that this was still a separate edition. And so therefore it wasn't really diluting the but as far as I'm aware, there hasn't been a case litigated with as kind of crystalline a version of the facts as you propose. And it would be really interesting to see what a court would do with that, because I think it's a fair point. I mean, I think there's a fair case to be made that if there's a contractual obligation to recognize the authenticity of a work or not to dilute that or deny the authenticity going forward, then that ought to be enforceable in contract, right? The question then becomes, does it matter? Right? Because at the end of the day, right, it's one thing for a court to say, artist, you are contractually obligated to say that work is authentic, but you can't force the art market to recognize it, right? So as it stands, I think these are all kind of really quixotic litigation, because even if they prevail in court, right, and get the court to say, no, this is the authentic artwork, and you can't deny its authenticity, the problem is the market might not believe it. And if the market doesn't believe it, then it just doesn't matter, because you can't force people to value that as a representation of commercial goodwill if they don't want to. They're not going to make the investment, right? If you can't sell in the market, then it doesn't have any value anymore. And actually, I would say probably the closest case to what you're describing is actually an NFT case. And it actually involves what's arguably the first ever NFT. So way back in, I believe it was 2014, a digital artist named Kevin McCoy was thinking about ways to monetize digital art, right? So digital artists have struggled with this problem for a long time, right? Because there's no object, right? And digital works can be infinitely reproduced. So how do you participate in the traditional art market if you can't create kind of unique objects? And that's what the NFT market was effectively designed to solve. The problem the NFT market was designed to solve for digital artists. So what he did was go on to a kind of fork of the Bitcoin blockchain at the time called Namecoin, and create an entry on the Namecoin blockchain that purported to be a record of the ownership of a digital artwork that he created called Quantum, right? He offered that up as an example and sold a different artwork in NFT form to this guy, Anil Dash, who's kind of a technologist in a public presentation. Okay, there's a peculiarity where the Namecoin blockchain erases itself about every 30 days unless you renew an entry. So this didn't really go anywhere. McCoy didn't renew the entry, and so it was written over. That particular segment of the Namecoin blockchain was written over, and everyone kind of forgot about it until 2020, when the NFT market started percolating again. And shortly after the first really huge sale, the Beeple 1,000 days, every days, for $100 million or whatever it was, Kevin McCoy was like, oh wait, I created the first NFT, I really ought to cash in on this. So what he did was recreate his first NFT on the Ethereum blockchain, auction it off at Sotheby's, and he got several $1 million for it from a collector. However, a creative NFT collector, right, NFT archaeologists like to call themselves, realized that this has actually been created on the Namecoin blockchain, and that the actual segment on the Namecoin blockchain still existed and could be obtained. So he went and bought the Namecoin segment that had included McCoy's NFT, but no longer included any of that data because it had been overwritten. And his argument was that, no, I actually own the real NFT or the real ledger entry associated with Quantum, and this Ethereum entry is just a recreation of it. It's not the authentic NFT. Brought a declaratory judgment action in the Southern District of New York, asking the court to declare that his NFT on the Namecoin blockchain was real and that the Ethereum NFT was not real. The court has declined to make such a judgment. They're still litigating and appealing it. I think it's a really interesting existential question, right? Or ontological question as to who's right. But at the end of the day, the practical question is, what are NFT collectors willing to buy? If anything, what do they recognize as real, as authentic, as opposed to inauthentic? But actually, I mean, now that I think of it, it's actually pretty close to what you're describing. McCoy says, no, that name coin entry isn't real, right? It was written over, it doesn't exist. The Ethereum one is real because I say it is. The collector says, no, this is the same blockchain segment that you used, and I own it now, and that's indisputable. The blockchain is proof, right? It's associated, it's in my wallet, it can't be anywhere else, therefore I have to be the owner and you can't deny it. So what happens there? The only difference there is he has no direct contract with McCoy and didn't even pay McCoy himself anything for this. So there is a kind of privity of contract issue, I think, but pretty close to what you're describing. Okay, the third one is a lot. So
Maybe other people also have questions. I mean,
well, they were so good. Let me. Yeah, sure. Yeah.
Yeah, I had a question about kind of touching again on like the market for art. Is it not kind of defining, like, how do you separate, you said at the beginning, like art that's being sold, like it's like resale value or kind of this investment versus art that people enjoy? Because to me, I think there's like, it's hard to distinguish those in some markets where you have like, okay, you have like a Rembrandt, which is going to have immense underlying value, like sketches are going to go for 40,000, whatever. But then there's also at the same time, for like some more completed work, there's people who are buying it for, like you said, as like investment, but also people who are just buying because they might actually be beautiful. And like, that's not like impact of, like, is that not the distinguishing feature? Like, for example, share, there's not people in the market buying the share because share is beautiful. And like, how do you separate those two? Because it seems to me like the underlying value of some of the best works is like this combination, like you said, between the ledger. It is also perhaps because there's like this common sense, like this is beautiful, and that's why it's valuable. How do you like distinguish the two?
Sure. Well, it's the distinction I'm trying to make when I distinguish between an investment market and a consumption market, right? So to the extent people are buying or appreciating artwork because they like what it looks like, or they are engaging in aesthetic appreciation, they're engaging in a form of consumption, right? They're liking whatever it is. When it comes to traditional artworks, right, that we think of as having to be authentic objects in order to truly be the artwork in question, well, there's a way in which owning the object enables you to exert some degree of control over the ability of people to engage in that form of aesthetic appreciation, right? But when it comes to digital artwork, right, I mean, you put it on the internet, everyone can see it just as well as everyone else. Everyone can engage in that same form of consumption. It's actually much more democratic. Ironically, a lot of the people who objected to the NFT market objected that, well, you're not really getting anything. I can right-click save and steal your artwork. I mean, they were just missing the point, right? I mean, this actually should be a plus rather than a minus, right? Now everyone can consume the artwork. Everyone can engage in the aesthetic appreciation. We don't have to create artificial limitations on the ability to consume the artworks in question. We can take advantage of the elimination of transactions costs on the consumption of digital goods rather than continuing to artificially limit the market in order to create artificial scarcity, right? That said, I mean, I think the response would be that, sometimes it's hard to know whether or not the investment is going to play out, right? But I don't think that's a problem, right? Because there's lots of times you make an investment and you don't know for sure whether the business opportunity, the business is ever really going to be successful, whether it's ever really going to materialize. You're, investing on a hope and a prayer, right? Maybe sometimes you're successful, but most of the time you're not. I think the same thing is true in the art market, right? You might buy something as a consumption good because you really like it, with the belief that it's at least possible that that artist will become famous in the future, right? So there's a kernel of an investment part as well. That may be delusional, right? In fact, in most cases, it's delusional, right? But it's conceivable that it could be the case. Sometimes an artist who was not well known or respected by the art market, wasn't valued by the art market, becomes valued in the future. There's no guarantee of that, right? So you can have both happening at the same time. They're not mutually exclusive. And in fact, I would say that, people who buy artwork as an investment, I mean, my assumption is they're more inclined to buy things they like than things they don't, maybe in part just because, you believe you have good taste and can predict what people are going to like more in the future, right? So you're sort of like taking that as relevant information in your investment decisions. What's more, it's easy to like something when you've invested a lot of money in it in the belief that it's going to be worth even more money in the future, right? I mean, if I think I've got a deal on a $20 million painting and I'm going to be able to sell it for $40 million in 5 years, man, that's my favorite goddamn painting around. I love that painting. And I think a great example of this, right, is there was an anecdote that was used by a bunch of researchers where they said that, they asked a bunch of visitors to the Louvre, right? If you had, imagine a world in which there were an absolutely perfect replica of the Mona Lisa. You could not, absolutely impossible to tell the difference from the real thing. But then the actual, real, authentic Mona Lisa was destroyed in a fire, right? So it's just a pile of ashes on the ground. Right? And at the other end of the Louvre is this perfect replica of the indistinguishable from the real thing, right? You're going to go to the Louvre. What do you want to see, right? The perfect replica or the pile of ashes on the ground? And the overwhelming majority of people said, I want to see the pile of ashes on the ground, right? Why is that? Well, I think that's because price communicates information. And it communicates information in ways that people understand very, very well, in ways that they don't understand art, right? I like to say art is a consumption good that consumers don't understand, right? But they understand money, and they understand that the Mona Lisa is the most expensive painting in the world, right? So when they look at the pile of ashes, what they see is a pile of money, and they understand money in a way that they don't understand art. So maybe that's a cynical way of answering your question, but I think that there's some truth to it.
Well, thank you very much. Unfortunately, we are running out of time, and I think that there might be another class that's coming in. I'm not
yes,
totally
it
sure.
sure looks
Yeah,
like
it looks like there is. So we should probably clear out. So let's have another round of applause for Brian.
Thank you very much.
Thank you so much, and as always, thank you everyone for coming.